Hello everyone. I am D.K.AMRUTHA from School of Excellence in Law. I am here to share my views about free legal aid, the various challenges and solutions to it. To begin with, the poor man looks upon the law as an enemy, not as a friend. For him, the law is always taking something away. What can we in contemporary Indian society do to assure the poor that they do not need to be afraid of the law? If the poor lack faith in our legal system, access to free legal aid in criminal cases, a fundamental right under the Indian Constitution, means nothing. Thus, India is not only a parliamentary democracy but also a constitutional democracy. The right to justice is now an inalienable, integral, and primordial part of the basic structure of the Constitution. As a step towards making the legal services help the poor and the deprived, judiciary has taken steps in the recent past. Poverty is not limited to developing countries only, but the developed countries also do have people who are poor and socially unequal. The Encyclopedia Britannica defines legal aid as the professional legal assistance given either free or for a nominal fee to some indigent person in need of such help. This is also called as pro bono verito services. Various schemes of legal aid were developed by Justice N.H. Bhagavati, then of Bombay High Court, and Justice Trevor Harris of Calcutta High Court. An explicit provision for legal aid is made under the most important instrument of international law, International Covenant on Civil and Political Rights 1966, Article 14, Clause 3, Subclause D. India has ratified this convention in 1976 and therefore it is under international obligation to provide free legal assistance to people who are in need. The main question is, how can India deliver on its constitutional promise for free legal aid? Article 14 reads, Equality before law. Equality before law implies the absence of any special privilege in favor of individuals and equal subject of all classes to ordinary law. Article 39A of Indian Constitution requires the state to secure that the operation of legal system promotes justice on basis of equal opportunity and shall in particular provide free legal aid to ensure that opportunities for securing justice are not denied to any citizen by reason of economic and other desirability. Moreover, Section 304 of the Criminal Procedure Code 1973 guarantees that when the accused is not represented by a pleader and where it appears to the court that accused has no sufficient means to engage a pleader, the court shall assign a pleader for his defense at the expense of the state. The real first step towards free legal aid was taken in 1987 when the Indian Parliament enacted the Legal Services Authorities Act, giving an expansive meaning to legal services by organizing Lok Adalats and promote justice on basis of equal opportunity. What are the inadequacies or challenges of the current system? There are four main reasons why the National Legal Service Authorities are not being able to deliver real legal aid. 1. There is a general lack of awareness of the availability of legal aid. 2. There is a perception that free service is incompatible with quality service. 3. There are not enough lawyers delivered by the legal service authorities. And 4th, lawyers generally are uninterested in providing competent legal assistance because of financial constraint. There are some suggestions here for a free legal aid. The poor illiterate should be imparted with legal knowledge and should be educated on their basic rights. For that, judiciary needs to support from state administration to conduct legal literacy program. The judiciary should focus more on legal aid because it is essential in this present scenario where gulf between have and have-nots is increasing day by day. An elimination of social and structural discrimination against the poor will be achieved when free legal aid is used as an important tool in bringing about distributive justice. There are a number of precedents as well as legislations to uphold the free legal aid, but they have just proven to be a myth for the masses due to their ineffective implementation. Free legal service authorities must be provided with sufficient funds by the state because no one should be deprived of professional advice and advice due to lack of funds. In the modern society, the system of justice in itself is very costly, complex, and cumbersome. Access to justice inheres the notion of justice. The majority of people in our country are subjected to this denial of access to justice and overtaken by despair and helplessness. They continue to remain victims of an exploitative society where economic power is concentrated in the hands of a few and it is used for the perpetuation of domination over large masses of human beings. The first step to achieving justice is to make justice visible, was said by Mahatma Gandhi. Thus, the legal aid program implemented will go a long way towards wiping the tears from the eyes of teeming millions of Indian people by advancing social justice and providing them equal access to the law and justice. The question that whether it is a myth or reality, it can be interpreted that the vision of the pioneers of the legal world is certainly turning into reality. The myth is only of its implementation, which will also take a real shape once certain minor reforms are executed. Thank you.